5 seconds to go. Start. The court reiterated that an investigation may be transferred to the CBI only in rare and exceptional cases. Stop. One factor that courts may consider is that such transfer is imperative to retain public confidence in the impartial working of the state agencies. Stop. This observation must be read with the observations made by the Constitution Bench in the case of Committee for Protection of Domestic Rights, West Bengal Supra, that mere allegations against the police do not constitute a sufficient basis to transfer the investigation. Stop. Para. In Romila Thapad versus Union of India, 2018 10 SCC 753, one of us, speaking for a three-judge bench of this court, Dr. D.Y. Chandrachud, judge dissenting, noted the dictum in a line of precedents, laying down the principle that the accused does not have a say in the matter of appointment of investigating agency. Stop. In reiterating this principle, this court relied upon its earlier decisions. Stop. This court observed, para. The consistent view of this court is that the accused cannot ask for changing the investigating agency or to do investigation in a particular manner, including for court-monitored investigation. Stop. Para. It has been held by this court in CBI versus Rajesh Gandhi, 1997, Criminal Law Journal 63, that no one can insist that an offence be investigated by a particular agency. Stop. We fully agree with the view in the aforesaid decision. Stop. An aggrieved person can only claim that the offence he alleges be investigated properly, but he has no right to claim that it be investigated by any particular agency of his choice. Stop. Para. The principle of law that emerges from the precedents of this court is that the power to transfer an investigation must be used sparingly and only in exceptional circumstances. Stop. In assessing the plea urged by the petitioner that the investigation must be transferred to the CBI, we are guided by the parameters laid down by this court for the exercise of that extraordinary power. Stop. Para. Bearing in mind the position of law as discussed above and in the facts, and circumstances of the case, we are of the opinion that the High Court has not committed any error in refusing to transfer the investigation to CBI. Stop. Even the learned counsel appearing on behalf of the appellant has not vehemently pressed such a prayer. Stop. We are in complete agreement with the view taken by the High Court insofar as refusing to transfer the investigation to CBI is concerned. Stop. Para. Now, so far as the power of the constitutional courts to order further investigation, reinvestigation, de novo investigation, even after the charge sheet is filed and charges are framed is concerned, the following decisions are required to be referred to, para. In the case of Bharti Tamang Supra, after taking into consideration the decisions of this court, in the case of Babu Bhai versus State of Gujarat, 2010-12, SCC 254, paras 40 and 42, and the subsequent decision of this court, in the case of Ram Jethmalani versus Union of India, 2011, 8 SCC 1, and other decision on the point, ultimately the principles, which are culled out are as under. Stop.